Morning, Judge.
Good morning. I hope everyone's doing well today.
Morning, Your Honor.
Good morning. Good morning, Ms. Lewis. How are you?
I'm good, Judge.
And Ms. Lopez, good to see you. Okay, do we have Mr. Finley? Good morning.
Good morning, Judge.
Ms. Helen, again, good morning. Courtroom Two, good morning. Are we ready to begin?
Yes, sir.
Okay, who do we have?
Yeah, Mr. Hamilton. Yeah, sorry, I don't have his position number.
What's his name?
Mr. Hamilton.
Hamilton.
It's position number 10.
Thank you.
And this is a negotiated plea, Judge.
Thank you, Finland. Good morning, Mr. Hamilton. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yeah.
Can you raise your right hand for me, please? Oh, do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, thank you. Good morning, Ms. Tortorella.
Good morning, Your Honor. How are you?
I'm doing well, thank you. You can proceed.
Yes, Your Honor. The state will be moving forward with the battery, family violence, battery, and criminal trespass charge for this case. The state's recommendation is for the battery, family violence, 12 months, serve 58 days, credit for time served 29 days, balance probated, no contact with the victim, and her name is Skylar Tapp. The last name is spelled T-A-P-P. Stay away from 2451 Old National Parkway, room 129 in College Park, Georgia. And that he taken FVIP class. For the battery, that will merge. The criminal trespass, damage to property, we're recommending 12 months, served 60 days, credit for time served 29 days, balance probated. Stay away, 40 hours of community service, and any restitution that is owed. We have not heard from the victim as far as restitution. So, but that charge will run concurrent to count 1, which is battery, family violence. The relevant convictions on his record, Your Honor, is
this negotiated, Ms. Tortorella?
Yeah.
Yes, Your Honor.
Okay, I don't need to hear the convictions if it's negotiated, okay?
Okay.
All right, so let me understand that he's pleading to battery, family violence, and criminal trespass, and the battery's merging into the battery, family violence. Is that correct?
That's correct, Your Honor.
Anything further, Ms. Tortorella?
Only that I just would like to ask opposing counsel if he stipulates to fact ID and venue
I do.
record. Thank you. That's it, Your Honor.
Okay, thank you. Mr. Finley?
Yes, Judge. We do agree to state's recommendation, and just one small thing I just want to clarify. So I know for the battery, it's 58 days, 29 time served, which would be time served. For the second offer, it's 60 days. So I just want to, I don't know if that's a mistake, if you guys want him to spend one more day.
No, we can make that that the same. Thank you.
Okay. I just wanted to make sure. So yes, yes, Judge, we do agree to the state's recommendation, and additionally, like we said, stipulate the factual basis venue ID.
Okay.
Excuse me, Your Honor.
Yes, sir.
I just got one question to ask you about the plea or whatever. Cause I'm on the walker and I got a broke leg, right? I'm just not trying to have to go to that class because I don't know if I could be able to make it. I'm not trying to, you know what I'm saying? I ain't trying to tell y'all that I'm gonna be there and I'm gonna make it every time y'all tell me to class. I'm on this walker. It's hard out there with this walker. I'm by myself, you feel me?
Well, it's my understanding, Mr. Hamilton, that you're going to be on probation for 12 months and you'll have 12 months to get this done, and hopefully your leg will heal in the meantime and you'll be able to get the classes done.
All right.
Okay, so Mr. Finley, do you need to talk to him because the negotiated plea includes the family violence intervention program, which is standard in these types of cases,
Right.
and which won't be waived in this case.
Right. And we did discuss that. Would you like to move forward, Mr. Hamilton, with the offer that we talked about?
Good.
Okay.
I'm sorry, was that a yes?
I said it's good. So, I mean, I asked you, I mean, you turned it down, sir. I'll take whatever. I'm trying to go home today.
Okay. It's my understanding, Mr. Hamilton, that you wish to plead guilty to battery, family violence, and criminal trespass. Is that correct?
Yeah.
Are you under the influence of any drugs or alcohol at the present time? That are not prescription drugs?
No. I don't even get my prescription drugs in here.
Say it again for me, sir.
I don't even get my prescription drugs in here. I'm mental health. They don't give me none of that.
Okay, so you're not under the influence of any drugs this morning, is that correct? That's either a yes or a no question,
No.
Mr. Hamilton. Thank you. You've been represented by counsel. Are you satisfied with your counsel's representation?
Yep.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yep.
Has anyone forced or coerced you to plead guilty?
Nope.
I will accept your plea as negotiated, Mr. Hamilton. You're going to have to be on probation for the entire 12 months, but I'm going to waive the probation fees while you're on probation to help you get and stay on your feet, okay?
Yeah.
All right. Good luck to you, sir.
You too, sir.
Judge,
Have a blessed day.
You do the same.
excuse me, Judge, was there a stay away or, a stay away?
I ain't fine for
There was a stay away and a no contact. It was stay
What was
away
the
from
address? What was the address on the stay away? I'm sorry, I didn't get it.
2451 Old National Parkway.
All right, thank you.
You're welcome.
Hold on, one judge, one moment, please, Judge. Good morning.
Good morning.
Yes. Judge position number 3, Mr. Creamer is next, please. Thank you.
What position was that, Your Honor?
Position number 3,
Position 3.
Mr. Creamer. And Ms. Tortorello, since this is a non-negotiated plea, I will need to hear the facts in this case. Let's see. Good morning, Mr. Creamer. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Sure.
Was that a yes?
Yes.
Thank you, sir. Can you raise your right hand for me to the best of your ability, Mr. Creamer? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
So, yes, sir.
Okay, thank you. You can put your hand down. Ms. Tortorello?
Yes, Your Honor, the state will be moving forward with terroristic threats, criminal trespass, and the public drunk charge. Our offer is for the terroristic threats, 12 months, served 30 days, credit for time served 6 days, anger management, no contact with the victims, their names, Frida Stokely, Frida spelled F as in Frank, R-E-D as in dog, A, and the last name is S-T-O-K-E-L-Y. The second victim's name is Gwendolyn Weaver. That's G-W-E-N as in Nancy, D-O-L-Y-N as in Nancy. Last name is Weaver, traditional spelling. That for the criminal trespass, it will be 12 months, served 30 days, credit for time served 6 days, 40 hours of community service, and that he stay away from the residence 3248 Ward Drive Southwest in Atlanta, Georgia. And that he, I already said 40 hours, and that would be concurrent to the first count, terroristic threats. And for public drunk is 12 months, served 30 days, credit for time served 6 days, and that will run concurrent with the rest of the charges. On July 10th, 2019, the defendant, Antonio Creamer, did commit the offense of terroristic threats when he threatened to commit a crime of violence with the purpose of terrorizing another by stating that he would return to 3248 Ward Drive Southwest in Atlanta, Fulton County, Georgia, and burn down the home of victim Frida Stokely, and both Ms. Stokely and victim Gwendolyn Weaver were inside. Said defendant did appear intoxicated within the curtilage and private residence of Ms. Stokely, which condition was made manifest by boisterous, vulgar, profane, and loud language when the defendant began to shout violent obscenities and threats to Ms. Stokely and Ms. Weaver. And said defendant did commit criminal trespass when he remained on the property of Ms. Stokely after being given notice to depart. There are no relevant convictions for this case, Your Honor. He does have 2 cycles out of Minnesota and 15 cycles in Georgia. Nothing further.
Finley?
Yes, Judge. The state is asking 30 days to serve. He has served 10 days. So after the 2-for-1, that would mean he would serve 5 more days incarcerated, Judge. Mr. Creamer, this event did happen in 2019. Since then, he has really been working on getting his life on track, Judge. He's been involved in what's called the Covenant Community Program, and the Covenant Community Program helped Mr. Creamer get a job, get housing. Through this, he works security at a church, and he's also had an apartment that he pays rent for himself. Rent was due on the 1st, and he has a check that's waiting for him. So he's very concerned about getting kicked out of his apartment. So we are asking for time served, Judge, so we can get him out and make sure that he holds on to that apartment.
Ms. Tortorella, you indicated for the terroristic threats, anger management. How much anger management were you requesting?
3 months.
And that's your understanding, Mr. Finley?
That's my understanding, Judge, and we would just ask that once he does complete the anger management and the community service, he could be not reporting.
No objection from the state.
All right. If you can unmute Courtroom Two, please. Mr. Creamer, it's my understanding that you wish to plead guilty to terroristic threats, criminal trespass, and public drunkenness. Is that correct?
Yes, sir. Request for permission to speak, sir.
Mr. Creamer, you have a right to remain silent. Anything you say can be used against you. I'm happy to let you speak with Mr. Finley if you have a question regarding the plea. So do you need to?
It's not a question, sir.
And Mr. Creamer, if it's involving the facts of the case, I would just advise you
Okay.
not to say anything.
Yes, sir. Yes, sir.
Okay. So my question was, it's my understanding that you wish to plead guilty to terroristic threats, criminal trespass, and public drunkenness. Is that correct?
Sir, yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Sir, no, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Sir, yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Sir, yes, sir.
Has anyone forced or coerced you to plead guilty?
Sir, no, sir.
I will accept your guilty pleas, Mr. Creamer. And for each, the only change I'm going to make to the recommendation is that it's going to be 12 months to serve, 20 days, credit for time served, 10 days, balance probated. I'm going to waive the probation fees while you're on probation to help you get and stay on your feet. And once you complete the terms of the probation, Mr. Creamer, it will go to a non-reporting status, okay?
Sir, yes, sir.
All right, good luck to you, Mr. Creamer.
Sir. Oh,
All right,
yes, sir. Thank you.
you're welcome.
Judge, I have position number 16. Next, please.
I'm sorry, tell me one more time, position
Position
6,
number 16, 1 6.
16, okay? And this is Mr. Carbo, is that correct?
Yes, Judge.
Good morning, sir. My name is Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can put your hand down. Good morning, Ms. Mitchell.
Good morning, Your Honor. The plea is the negotiated plea. The state's plea recommendation is 12 months to serve, 30 days confinement, credit for time served 15 days, balance probated, a stay away from MARTA consistent with any active suspension, 60-hour community service. 60-hour community service and no alcohol, drugs, and weapons. Nothing further.
Mr. Finley?
Yes, Judge. We do agree to the state's recommendation and additionally stipulate the factual basis venue and ID. We would just ask that once Mr. Carbo does complete the community service, that he could the probation could either be terminated or not reporting, Judge.
Any objection to termination, Ms. Mitchell?
No, Your Honor.
Okay. I'm sorry, tell me again what he's pleading to.
Your Honor, it's terroristic threats, simple assault, criminal trespass, two counts of certain acts on a bus rail station prohibited, and then obstruction of law enforcement.
The sentence is the same for all charges. I just want to make sure I get it right on the sentence sheets.
That's my understanding. Is that correct?
Yes.
Okay. Mr. Carbo, it's my understanding that you wish to plead guilty to terroristic threats, simple assault, criminal trespass, certain acts on a bus rail prohibited, 2 counts of that, and willful obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
Was that a yes?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept the plea as negotiated. I'm going to waive the probation fees for you, Mr. Carbo, while you're on probation, and as soon as you complete the terms of the probation, it's going to terminate, okay?
Yes, sir.
All right, so it means the quicker you get it done, the quicker you won't be on probation. Have a good day, sir.
Judge, I have position number 8, please. Hold on one moment. Judge, I have position number 8, please.
Okay,
Morning, how y'all doing?
good morning. This is Mr. Ford, is that right?
Yes,
Good morning, Mr. Ford. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
yes,
Thank you. Can you raise your right hand for me, Mr. Ford?
yes, sir.
Thank you. Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, your honor.
Okay, you can put your hand down, Mr. Ford. Ms. Tortorella?
Yes, Your Honor. What's the position for this case? Is it negotiated or?
I have down that as a negotiated plea. It's position number 8.
Yeah, that's correct. Negotiated plea.
Thank you. For this case, we're moving forward with the state's moving forward with the criminal trespass charge. The offer is 12 months, serve 19 days, credit for time served 19 days, balance suspended, and to stay away from the incident location, which is the Ritz-Carlton Hotel at 181 Peachtree Road, Northeast in Atlanta, Georgia. And nothing further from the state.
Finley?
Yes, Judge. That's our understanding of the recommendation, time served and no probation. And we do agree and additionally stipulate the factual basis, venue, and ID.
Okay. Mr. Ford, it's my understanding that you wish to plead guilty to criminal trespass. Is that correct?
Correct, Your Honor.
Did you hear me, Mr. Ford?
Yeah, I heard you.
Okay. Do you wish to plead guilty to criminal trespass?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, I'm satisfied.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the guilty plea as negotiated, Mr. Ford. Good luck to you, sir.
All right.
Judge, I have position number 35, Tucker.
Good morning, Mr. Tucker. I'm Judge Eric Morrow. This is the state, all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Good morning, yes.
Mr. Tucker, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You can put your hand down. Good morning, Mr. Cheney. Is this your case?
It is, Your Honor.
You can proceed.
This is a negotiated plea for theft of services misdemeanor. The plea recommendation, Your Honor, is 12 months, served 6 days, credit for time served of 6 days. It's probated. Stay away from a Ray's in the City restaurant located at 240 Peachtree Street Northwest. Your Honor, if the defense will stipulate to factual basis, ID and venue, that is our case, Your Honor.
Okay, why are you requesting that if it's basically time served, what's he gonna be on probation for?
No, Your Honor, it's 12 months probation to serve 6 days, credit for time served, which would release him today. The probation for theft of services would be basically leaving the restaurant without paying. Therefore, part and parcel of the negotiated plea would be the probated portion to stay away from that restaurant.
Normally, we ask for, the state asks that when there's nothing that goes along with probation except for stay away, that the balance is suspended as opposed to him being on probation.
Okay, Your Honor, I was not used to that plea recommendation. Basically, what I was asking for is 12 months probation. I don't know how we are going to frame that. He has served 6 days in jail. And basically what I was saying is he's getting credit for that 6 days, but where the offer negotiated is 12 months of probation.
Okay. Well, I'm not gonna put him on probation and he doesn't have anything to do on probation. He doesn't have community service. All he has is a stay away. So the balance is gonna be suspended. You wanna weigh in on this, Mr. Walker?
It's fine to have a suspended sentence, Your Honor.
Thank you. All right. Who's representing Mr. Tucker? Ms. Helen on the line? Okay,
Yes,
is
Your
this
Honor.
case, Ms.
I
Helen?
apologize. Yes, Judge.
Okay, did you hear that conversation?
Yes, Judge.
Okay, go ahead.
Give me 1 second, Your Honor. So, Judge, we are going to have a non-negotiated plea today.
It's 12 months to serve 6 days, credit for time served 6 days, balance suspended.
I apologize, Judge, this is a negotiated plea. I'm looking at my notes. I apologize.
Okay,
And Judge, we do stipulate to the factual basis, venue, and ID.
and that is your understanding of the negotiated plea, Ms. Helen?
Yes, Your Honor.
All right. Can you unmute Courtroom Two, please? Mr. Tucker, it's my understanding that you wish to plead guilty to theft of service. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol
No.
today? You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I will accept the guilty plea as negotiated, Mr. Tucker. 12 months to serve, 6 days, credit for time served, 6 days, balance suspended. Good luck to you, sir.
Thank you.
Thank you, Your Honor.
Excuse me, AST Chenny, can I please have your first name?
It's Kirk, K-I-R-K.
Thank you.
Yes, ma'am.
Judge, I have position number 14 next, please.
Position 14, Hilliard,
Yes, Judge.
and this is going to be an arraignment this morning. Who's representing Mr. Hilliard? Mr. Finley, are you on the line?
I can text him, Judge. Give me 1 second.
Okay. You with me, Mr. Finley?
All right, I was on the phone with the jail, one of the clients. I apologize.
Okay, all right. We're on position number 14, Mr. Hilliard. It's my understanding that this is going to be an arraignment this morning. Is that right?
That's correct, Judge.
Good morning, Mr. Hilliard. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? You're on mute, Courtroom Two. Thank you. You agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, Mr. Hilliard? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, sir. Thank you. Mr. Hilliard, you've been charged in case 22 CR 002297J with criminal trespass, giving false information to law enforcement officer, and loitering and prowling. Each of these charges carries with it a maximum of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
I do.
How do you plead to these charges, Mr. Hilliard? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Sir, your case will be returned to the division judge and you will get notification of your next hearing date, okay?
Okay.
All right, good luck to you, Mr. Hilliard.
Judge, I have position number 20. Martinez is next, please.
Ms. Heller, this is going to be an arraignment and a bond hearing, is that correct?
Correct, Judge.
Good morning, Mr. Martinez. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me, sir?
Yeah, you're fine.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Yeah, you can put your hand down. Thank you, sir. Mr. Martinez, you've been charged in case 22 CR 002308B with battery family violence. This charge carries a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Your Honor.
How do you plead to this charge, Mr. Martinez? Guilty or not guilty?
Not guilty by far.
Okay, very good. We will record your not guilty plea. Your case will be returned to the division judge, and you will receive notification of your next hearing date. Given that this is a bond hearing or a request for modification of bond, Ms. Harrison, is there a history?
Good morning, Your Honor.
Good morning, Ms. Harrison. How are you today?
I'm good. GCIC indicates one arrest out of New York in 2016. No disposition is listed. I'm also showing an open case for criminal damage to property, second degree in aggravated assault, 21 CP 201300. No convictions listed on his GCIC.
And is that ever, I'm sorry, where's the aggravated assault pending?
Fulton County.
Okay. Ms. Helen?
Yes, Your Honor.
What is the current bond?
The current bond is a $10,000 surety, Judge.
And do you know who issued that bond? Did I issue that?
Yes, you did,
Okay,
Judge.
apparently I issued it on April 18th. Okay, go ahead, Ms. Helen.
Yes, Your Honor. Mr. Martinez is 30 years old. He just recently had a birthday, Your Honor. As pretrial read his history, we only have the one arrest in 2016 in New York, as well as the open case here or open case for the criminal damage and aggravated assault in Fulton County. And then there's my case. This is not a violent, long-standing criminal. This is not this individual. It's not Mr. Martinez. He does have an open case, and he does understand how serious these charges are, Your Honor. However, being 30 years old, due to this arrest, he's lost all employment, and he's the main person bonding himself out. He's the main person trying to accumulate $10,000 for a surety bond. That's why we're first asking for a signature bond, Your Honor. Based on his history and the Ayala factors, I do not believe that he will reoffend. He understands how serious these open cases are. Intimidating the witness. He has no contact with that individual or any accused party mentioned here, Your Honor, and understands the seriousness of that. And that's what I went over with Mr. Martinez when I spoke to him. And then thirdly, he's not a danger to the community. He does not have a history, long-standing, of being a danger to the community, Your Honor. And again, I do believe he will come to all of his court dates. He is 30 years old, has just turned 30, has lost all income or receiving income after being incarcerated. The bond right now is $10,000. We are asking for a signature bond. If not that signature bond, Your Honor, we're asking for a substantial modification. He cannot afford the $10,000 surety. We are asking for a $2,000 $500 surety for Mr. Martinez this morning.
Okay, a $10,000 surety bond is unusual for me. There must have been a reason behind it. Did the aggravated assault involve the same alleged victim as in this case? Okay.
Yes, Your Honor.
So that's probably
Also,
why.
Judge, it was a pretrial SOB, and that bond was surrendered with this arrest.
Oh, it was a.
Well, for the aggravated assault strangulation with the same victim, he actually was given a 10,000 surety bond. He received a signature or unsecured release bond for the damage to property when he broke her television. But he was given a $10,000 surety bond and a no further contact with the victim in this case, and a stay away from her address, which he violated again for this battle.
So he had allegedly had the aggravated assault first, same victim, and then we had the same allegations for the April 15th, 2020 allegations of battery, family violence. Is that correct?
Right. He went from strangling her to then beating her. Well,
Okay.
not beating her, grabbing her.
All right. So Ms. Helen, I knew that this was unusual for me, and I know that there was a reason behind it. You have anything further?
I do, Judge. Again, 10,000 is a very high bond. He cannot make. Essentially, that's a no bond, Your Honor. And again, when I spoke to Mr. Martinez, he is denying these allegations because they're still open. He is taking both cases to trial, Judge. So, with a $10,000 bond, that is officially a no bond for Mr. Martinez.
Well, if they're withdrawing the $10,000 signature bond that he was given previously, then it's going to be more than just this $10,000.
And Your Honor, if I may, we've also
Yes,
spoken
Ms.
to
Mitchell.
We've also spoken to the victim on 2 different occasions, and she was consistent in saying that she was very afraid of this defendant. She believes if he gets out of jail, he's going to come back to her home and harm her. She stated she wasn't aware of the previous bond, which is why she even allowed him back at the house. And she was adamant about the no contact and the stay away. So at this point, we have serious concerns of witness intimidation as well.
And Judge, if I could just comment, I hear that Ayala factor of a witness intimidation, but the individual saying she didn't know from a July 9, 2021, apparently the charge of aggravated assault by strangulation, she didn't know that individual is not supposed to be around her. Mr. Martinez knows he's not supposed to be around her, and he has no contact with her. We went over that in detail. So Mr. Martinez understands the seriousness of these charges and will be 2 football fields from this individual.
Okay, Ms. Helen, all the other conditions are going to remain the same. I will lower the bond from a $10,000 surety to a $5,000 surety. If you will make
Mr.
that
Martinez, did you hear that?
Yes, ma'am, I have.
Thank you.
I'm not gonna lie to
Mr.
you.
Martinez, you have a right to remain silent,
Yes, I
sir.
understand. I have a right to remain silent. Anything I do will be used against me. I understand that. I've taken poli-sci courses. I'm fully aware of the situation.
Mr. Martinez, please do not talk to the judge in that manner. If we need to take a sidebar and talk to each other, we can. But the judge,
There's no need for a sidebar, because all I'm gonna say is that I have no intention of pleading guilty for anything. I'm not negotiating anything. I have a set of witnesses that can prove without a doubt that I did not touch her, that she had fell down during the day, and there's also proof.
no details, Mr. Martinez. Just let the judge know how you feel, but no details, okay?
All right, so I've made my ruling on that, Ms. Helen, and if you'll get that to
I will, Your Honor.
Mr. Martinez. Who do we have next?
Position number 6. First.
And this is Jeremy Ellis, is that correct?
Yes,
Mr. Ellis?
yes, sir.
Good morning, Mr. Ellis. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Now, can you raise your right hand for me, Mr. Ellis? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir, I did.
Okay, good. You can put your hand down. Thank you. Ms. Tortorella?
Yes, Your Honor. This defendant's being charged with battery family violence. The state will move forward with this charge. The offer for this case is 12 months served 44 days, credit for time served 22 days, balance probated, family violence intervention program, absolutely no contact with the victim. Her name is Yvonne Dobargains. First name is I-V as in Victor, O-N as in Nancy, N as in Nancy, E. Last name is D as in dog, O, B as in boy, A-R, G-A, N as in Nancy, E-S. To stay away from the incident location at 96 Georgia Avenue, apartment number 4 in Atlanta, Georgia. And that's it, Your Honor. Also, the victim is present at the virtual Zoom hearing, Your Honor, if she would like to speak after.
Okay. Mr. Finley, do you want Ms. DeBorg to speak first, or would you like to go?
She can go ahead, Judge.
Okay. Ma'am, if you're on the line, I'll need for you to unmute your self and activate your camera for me.
Hi,
All right.
Judge. How are you?
Good morning. I'm fine, ma'am. Can you
Good
raise your
morning.
right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, ma'am. What would you like to tell the court?
I just wanted to give my comments. It's been a long time since his case was heard, and he just deserves to be in jail for what he did.
Okay. Anything further, ma'am?
No, sir.
All right. Thank you, ma'am. We appreciate you being here this morning.
Thank you.
And Your Honor, just to add to that, the victim after this occurred has, despite the no contact order or harassment, it was actually no violent contact where he was not to harass or intimidate the victim. She has been receiving random text messages. We have copies of those. However, I just hope that he is clear that he has absolutely no contact with her, or that.
I'll make it clear, Ms. Tortorella.
Thank you.
You're welcome. Mr. Finley?
Yes, Judge. We do agree to the state's recommendation. According to my conversation with Mr. Ellis, he did agree that he's to have no contact with her. And additionally, we would just ask that once he does complete the FIP class, that he get a speed not reporting, Judge.
Your Honor, we would
I'm gonna have him report the entire 12 months, Mr. Finley.
Understood.
Okay. Your client has his hand up.
Yes, Mr. Ellis, if it's involving the details or facts of the case, I'd recommend you
No, it doesn't. I live 2.5 hours away, from here. I'm in the middle of closing on a house. So I've had to postpone that due to this. It's the third time I've been arrested for this charge. This charge happened in 2014, been 8 years. Public defender, Finley, I thought that you told me I was getting time served for this.
You are getting time served
So that would mean I'd be getting released today.
within 24 hours. Yeah. The court, if the jail does the 2-for-1. Yes, sir.
Okay, there's no way that I could get this probation transferred to where I live.
You'll have to speak with probation regarding that, Mr. Ellis.
So am I getting 2-for-1 for this charge?
The jail normally gives 2-for-1, Mr. Ellis.
So, I mean, does that mean I'm getting out today is what I'm trying to figure out?
You're gonna get out as soon as the jail can process you out,
Okay,
Mr. Ellis. Mr. Finley can't tell you exactly when that's gonna be because that's up to the jail and their procedures. But as soon as they get around to processing you out, then you will be getting out. You understand?
yes, sir.
Okay, you have any other questions?
No, sir.
Okay, you have anything further, Mr. Finley?
Nothing further, Judge.
Mr. Ellis, it's my understanding that you wish to plead guilty to battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yeah, I do.
Has anyone forced or coerced you to plead guilty?
They have not.
Okay, I am going to accept the plea as negotiated, Mr. Ellis, and I do want to make it clear to you that no contact means absolutely no contact. It means no personal contact, no phone contact, no email contact, no letter writing contact, no contact whatsoever. You understand me?
Of course, sir.
Okay, so I'm going to accept the plea as negotiated. You're going to be on probation for the entire 12 months, but I'm going to waive the probation fees while you're on probation to help you get and stay on your feet, okay?
All right, awesome. Thank you.
All right, very good. Good luck to you, Mr. Ellis.
Appreciate it.
In clarification, excuse me, can I please clarify the stay away addresses in one?
Mr. Tortorello, Ms. Tortorello, can you give us the stay away address, please?
Yes, it's 396 Georgia Avenue, apartment number 4, Atlanta, Georgia.
Thank you.
You're welcome.
All right, who do we have next?
Position number 7. Fabian.
Good morning.
Good morning, Your Honor. I'm Ben Sessions for Mr. Fabian.
Good morning, Mr. Sessions. How are you today?
I'm doing well, Judge. Thank you.
Good. Good morning to you, Mr. Fabian. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. You have your case heard by video. Mr. Sessions, what are we doing with Mr. Fabian today?
Your Honor, Mr. Fabian has a DUI that was pending before Judge Richardson. That case had been set for motions, and Mr. Fabian missed that court date because he subsequently become homeless, didn't have a good address, and wasn't able to update that to the court. So didn't receive notice and bench warranted on that date, Your Honor. He has a $1,000 surety bond on both a DUI and a family violence battery charge, I believe. I don't represent him on the family violence battery charge, but I will represent him on that case to help him in resolving it. We had an offer on the DUI, Your Honor, that I believe will resolve that case. And as I said, I will enter an appearance on the family violence battery to represent him in that case to help him resolve it. His father's on the call, Your Honor. He verified for me that he is homeless. Does have some mental health issues that are going on related to military service. And I'm asking Judge that you reinstate his bond or give him a signature bond in the alternative so that we can get him out and hopefully get these cases done for him. His sister is also on the call. She's identified as Aisha. So he does have good contacts here in the state. They will obviously help in facilitating this now that they know this is a problem with the contact. They cannot come up with a $1,000 bond, Your Honor.
And
Okay.
Your Honor,
Hold on, Mr. Tortorella, I'll get right with you. I don't have, the only thing that I have on my calendar today, Mr. Sessions, is a DUI charge. I don't have anything regarding a family violence charge. Is he being held on family violence also, or does he have a
I don't-
signature bond on that charge?
I don't believe that he is, Your Honor.
Okay, so
I
this is
believe
the
that
only charge he's being held on.
That's correct, as far as I know, Your Honor.
Okay, all right. Yes, Ms. Tortorella.
if you need that case number, Your Honor, it's 20 CR 00. I'm sorry. It's 20 CR 002105F. I have a global offer for the opposing counsel if he's interested. If there is in fact no resolution today, given the fact that the battery family violence is a subsequent arrest from the DUI case, the state will be moving to revoke his bond for this DUI case before this court today.
And what is that bond?
That bond, Your Honor, I believe is a $1,000 surety bond, and it's on a bench warrant. So because he's missed court.
Okay, Mr. Sessions, are you interested in speaking with the solicitor's office today regarding resolution of these cases?
I received the global offer. Honestly, I've already received a reckless driving offer from the solicitor that's handling the case in Judge Richardson's courtroom. The offer that they sent me was for a guilty plea to a DUI. So the offer was inconsistent with the offer that's already been extended to us there. So
In Your Honor, if Mr. Attorney Sessions, I would gladly honor that offer if you send me some sort of documentation about what that offer is, and I will incorporate that to the global offer.
Your Honor, rather than rush through, I don't know anything about the family violence. I certainly wouldn't feel comfortable pleading Mr. Fabian to a family violence charge. I just asked the court allow him either reinstate that bond or allow him to post a signature bond, Your Honor, to get him released. I don't think there's any chance that he's going to miss court going forward, given the interaction that I've had with his father and his sister who are on the call as well, Your Honor.
All right, so let's see. And he does have a good address now, Mr. Sessions. Is that what you're telling me?
His father will provide the address for us, and I know that Aisha is on the call. That is his sister. Aisha, if you would please message me with that address.
All right. And have you entered a notice of appearance on this case?
On the DUI, I have, Your Honor.
Okay.
As to the family violence battery, Your Honor, I didn't know about the family violence battery until someone messaged me about that after he was in custody from the court. I will enter an appearance on that case as well, Your Honor, to facilitate the resolution of it.
All right. And what was the previous bond on the DUI?
I am unsure, Your Honor.
Okay.
I know that there was $1,000 that had been set by the jail while he had already been in there, Your Honor.
Anything further, Ms. Tortorella?
Yes, Your Honor. I'm just checking my notes here. We will also move to revoke bond on the battery family violence charge, as he does have a subsequent open felony case for entering auto. That's 20 ST 175985. Offense date is April 6, 2020. Nothing further.
Okay. So the only thing that I'm ruling on today is this DUI. And given what Attorney Sessions has told me, that he has a good address and that he missed court because of not having a permanent residence, I'm going to reinstate, or I'm going to give him $1,000 signature bond through the jail on the DUI charge. All right, Mr. Sessions, the way we normally do it in this court is that if there's a modification, then the attorney prepares it for the court and gets it to us. Can you do that?
Yes, Your Honor, I can. Should I send that to Miss Lewis, Your Honor?
Yes, please.
I sure will.
All right. Anything further on Mr. Fabian? All right.
No, Your Honor.
All right. You have a good day. Thank you.
Thank you so much.
Good luck to you, Mr. Fabian. Ms.
Position number,
Lewis, do you have everything you need? Ms. Lewis?
Yeah, Judge, I had just had a question on one of the sentence that we did with, position number 16. I know he has several charges. Is the state asking him to do 360 hours of community service? Because you said that all the sentences
No,
is the
he should
same.
only have community service on one of those charges.
That's the one I want to iterate which one it is, because they were saying the
Okay.
charges had the same.
Tell me what case this is, Ms. Lewis?
Position number 16.
16. All right, who represented that? Was this your case, Ms. Mitchell?
Yes, Your Honor.
Which charge do you want the community service to go with?
We can do it on the assault.
Okay. Anything further, Ms. Lewis?
No, that's it. So I just want that clarified.
Okay, thank you, that's fine. All right, who we have in courtroom 2 now?
Judge, position number 5, please.
Okay. Good morning, Mr. Elliott. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Your Honor, I do.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor, I do.
Thank you. You can put your hand down, Mr. Elliott. It's my understanding, Mr. Filling, that this is going to be a negotiated plea.
That's correct, Judge.
Ms. Tortorella?
Sorry, I was on mute, Your Honor.
Okay.
Yes, the state's moving forward with the simple battery family violence charge. The offer is 12 months, serve 30 days, credit for time served 15 days, balanced probated, family violence intervention program, no contact with the victim. And her name is, their names, victim number, there's 3 victims. Victim number 1 is Morgan Bird Holmes. Bird Holmes is spelled B as in boy, Y-R-D hyphen Holmes, traditional spelling. Victim number 2's name is Oshani Smith. That's O-S-H-A-N as in Nancy I. And then Smith is the traditional spelling, and a juvenile with the initials N-S. To stay away from 7 Old Holcomb Bridge Way in Roswell, Georgia. And he have do 40 hours of community service, nothing further.
Mr. Finley?
Yes, Judge. We do agree to the state's recommendation, and Mr. Elliott understands that he has to do the family violence intervention course as well as the community service. We just ask that once he does complete each of those, if he could be on either non-reporting status or if their probation could be terminated, Judge. And additionally, finances are an issue in Mr. Elliott's life, so just asking for their probation fees to be waived.
Any objection to non-reporting, Ms. Tortorella?
No objection, Your Honor.
Mr. Elliott, it's my understanding that you wish to plead guilty to simple battery family violence. Is that correct? You're on mute. Thank you.
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, I'm not, Your Honor.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Very satisfied, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir, that's my understanding.
Has anyone forced or coerced you to plead guilty?
No, sir, I've done that under free will.
Okay, thank you. Mr. Elliott, I will accept the plea as negotiated. I am going to waive the probation fees while you're on probation, and as soon as you complete the terms of the probation, it'll go to a non-reporting status, okay?
Thank you so much, Your Honor.
Good luck to you, Mr. Elliott.
Thank you.
Position number 11 is next, Judge.
Okay. This is going to be a negotiated plea also.
That's correct, Judge.
36 is.
Good morning, Mr. Hampton. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Ms. Tortorella?
Yes, Your Honor. He is being charged with battery, family violence, and the state is moving forward with this charge. The offer is a 12 months served, 22 days, credit for time served, 11 days, balance probated, no contact with the victim. And the victim's name is Tiffany Fleming. The first name is spelled T as in Tom, I, F as in Frank, F as in Frank, A, N as in Nancy, I-E. Fleming is spelled F as in Frank, L-E, M as in Mary, I-N-G. To stay away from 2471 Old National Parkway, room 245 in College Park, Georgia. That he also take a family violence intervention class, that he complete the program, and nothing further from the state, Your Honor.
Mr. Finley?
Yes, Judge. That is our understanding of the recommendation and offer, of which we do agree, and additionally stipulate the factual basis, venue and ID, and we just ask that the probation fees could be waived for Mr. Hampton.
Okay. And do you want him to stay on probation the entire time?
If he could, yeah, once he completes those conditions, if he could be on not reporting or termination, Judge.
Your Honor, we object to this. He has a subsequent arrest. I believe it is still open, and it's out of Cobb County, Your Honor. Battery arrest, 10/31/2021.
Okay. Mr. Hampton, it's my understanding that you wish to plead guilty to battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol today?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept the plea as negotiated, Mr. Hampton. I'm going to waive the probation fees for you while you're on probation, but you're going to have to report the entire time, okay?
Yes, sir.
All right, good luck to you, Mr. Hampton.
Position number 15 is next, Judge.
Okay. This is going to be an arraignment and a bond hearing, is that correct?
It cut off, Judge. What position are we at?
Position 15.
Yes, that's correct, Judge.
Okay, good morning, Mr. Houston. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Houston. You have been.
I'm sorry.
Okay. Mr. Houston, you have been charged in case 20 CR 003057E with battery against a female who is pregnant and cruelty to children in the 3rd degree. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
I do, Judge.
How do you plead to these charges, Mr. Houston? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. What's the current bond?
Your Honor, it's a $10,000 cash bond. And just to give you the procedural posture of this case, Your Honor, the state filed a motion to revoke bond on this defendant's bond on January 15th, 2021. The defendant's bond was revoked on April 22nd, 2022 in an order signed by Judge Morrison, and the defendant was granted a cash bond totaling $10,000. And I would like the court to take judicial notice under OCGA 24-2-201. The bond revocation order can be viewed in the state's Fulton County's system in Odyssey under case manager under case number 20 CR 003057E. Your Honor, we're just asking for you to honor this Judge Morrison's ruling. In the order, it does mention part of her reasoning was she heard the officer's testimony on the stand as far as his subsequent aggravated assault case, 21 CP 199778. And it involves the same victim where
Ms. Tortorella, I'm sorry, Ms. Tortorella, let me stop you there. I'm not going to change Judge Morrison's bond on this matter. Mr. Finland, if you or your office want to change the bond, you'll have to go back to Judge Morrison, okay?
Understood.
Apparently she's gone into detail hearing this case, and I'm reticent to change something that I've not heard. All right, so good luck to you, Mr. Houston. I'm sorry to interrupt you, Ms. Tortorella, but I knew that I wasn't going to change it, okay?
No problem, Your Honor. Thank you.
Who do we have next?
21, Judge.
Okay. And this is also going to be an arraignment and a bond hearing, is that correct?
That's correct, Judge. Can I get the position number again, just to make sure?
Yes, Mr. McLeod, position 21.
That's correct.
Good morning, Mr. McLeod. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Your Honor.
Thank you. Can you raise your right hand for me, Mr. McLeod? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Okay, you can put your hand down. Thank you, sir. Mr. McLeod, you've been charged in case 22 CR 002439F with battery and cruelty to children in the 3rd degree. Each of these charges carries with it a maximum penalty of 12 months in jail and/or a $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Your Honor.
How do you plead to these charges, Mr. McLeod? Guilty or not guilty?
Here you go.
Not guilty, Mr. McLeod.
I plead not guilty, of course.
Okay, so we'll record your not guilty plea, Mr. McLeod. Your case will be returned to the division judge, and you will get notification of your next hearing date. Ms. Mitchell, what's the current bond?
Your Honor, it's as to count 1, $20,000, count 2, $5,000, totaling a $25,000 surety. And the state's will request that that bond be reduced to $15,000 surety. So 10,000 as to count 1, and the 5,000 for count 2 will remain. Your Honor, in this case, the defendant battered Miss Aaliyah Malone by striking her in the face several times, causing her face to swell and bleed with a knot on her forehead. And the defendant did so in front of her 2 kids. It started when Miss Malone asked the defendant to watch the kids while she showered. He became enraged, kicked the bathroom door in, and started beating her while she was in the tub. Miss Malone went with the defendant to a bus later that same day, and while in the parking lot, he began to strike her in the face several times in front of the kids. So based on that, I mean, the state is still gonna request that this bond remain at a significant amount. At this point, a $15,000 surety. He also, I believe, has an open case for battery family violence from 2021. So based on that, we are requesting the surety bond.
Okay. Ms. Harrison, can you do you have the complete history for me?
Yes, Judge, he has 4 cycles. Last arrest was April of this year, but prior to that, he has a 2021 arrest for battery family violence in Union City. No disposition listed on that charge.
Okay, so the only thing he has is 1 arrest in 2021 for battery family violence. Is that what I'm hearing?
He has 4 cycles, but
Okay.
yes, those were his last 2 arrests. Prior to that, the last contact with law enforcement was 2012.
Okay. Thank you. Ms. Helen?
Yes, Your Honor. Mr. McLeod is 27 years old. He's a lifetime resident of Fulton County, and so is his family. And just getting into the Ayala factors, because we are asking for a bond reduction, Judge, even more significant than the 10,000 on the battery. Judge, we're asking for a reduction to 2,500 for the battery, and the cruelty to the children in the third degree of 1,000 for a total bond of a $4,000 bond, Your Honor. Because a $20,000 bond is officially a no bond for Mr. McLeod, he cannot afford that bond, Your Honor. So we are asking for that reduction. He has not been working since he's been incarcerated, and due to his history, Judge, due to his history, we are going to first ask for a signature bond. If you feel that he is ineligible for that signature bond, we're going to ask for that modification and the modification of a reduction. He knows he has no contact with, it's actually pronounced Aaliyah, no contact, not third party, not someone else. And they share a child together, I believe an 8-month-old girl. We are just asking for third party visitation be established for Mr. McLeod. And if he could return with a one-time escort to retrieve any items from the location or the shared living space with Miss Aaliyah, he would like to be able to do that, Judge. But first and foremost, we are asking for a signature bond, again, due to his history. This is not a long-standing violent offender. However, he is coming into contact with said accuser Aaliyah, and we would like for it to be distant. So we understand the stay away. We understand third-party visitation. I do believe he'll come to all of his court dates. I do not believe he'll be reoffending once he gets out on bond. I do not believe, again, he will have any contact whatsoever with Miss Aaliyah. So there will be no witness intimidation, Judge, and he's not a danger to the community, again, 4 cycles. I just want to encourage him to understand there is no contact with Miss Aaliyah.
Okay, so spell the alleged victim's name, please.
I have it as A-L-I-Y-A-Y, but it's pronounced Aaliyah.
And what's the last name?
Malone, M-A-L-O-N-E.
Correct, Judge.
And what's the stay away address?
6300 Oakley Road, Union City.
Okay, so for the battery, it's going to be a $3,000 surety. For the cruelty, $1,000 surety, making it a total of a $4,000 surety. No further contact with Ms. Malone. Stay away from the Oakley Road address. He can go back there one time with law enforcement to retrieve any belongings that he may have there. And if I am reticent to keep a father from his child, so he can have third-party visitation with the child. No drugs, alcohol, or weapons while out on bond. Did you get all that, Ms. Helen?
Understood, Judge. Mr. McLeod, did you hear all those conditions?
I did.
Thank you.
All right, good luck to you, Mr. McLeod.
Thank you.
Judge, I have position number 24. Next, please.
And this is going to be a negotiated plea.
Correct, Judge.
Good morning, Mr. Pryor. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, Mr. Pryor? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Ms. Mitchell?
Yes, Your Honor. We're offering time served plea, credit for time served 23 days, balance suspended, nothing further.
Yes, Your Honor, that is our understanding of the plea. We accept that plea. We stipulate to the factual basis, venue, and ID.
Pryor, it's my understanding that you wish to plead guilty to willful obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Pryor. Good luck to you, sir.
Thanks, sir.
Thank you, Judge.
Judge, I have an announcement, please. Position number 36, Mr. Bond, he was released. He's not in custody.
Okay,
That's all I have in courtroom 2. You should be able to go to Union City, South Annex next, please.
okay, very good. I'll see you this afternoon.
Thank you, Judge.
Good morning, Your Honor.
Hi, Officer Milton, how are you today?
I'm well, and you?
I'm doing well also, thank you. Who do we have?
Miss Rowland, position 27.
Okay,
That'll be a negotiated plea, Judge.
good morning, Ms. Rowland. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, I do.
Thank you. Can you raise your right hand for me, ma'am? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, Ms. Rowland. Ms. Mitchell?
Yes. Your Honor, our recommendation is time served, credit for time served 16 days, ballot suspended, no further contact with Dan Trius, spelled DANTARIUS, Tillman, and a stay away from 2432 Verbena Circle, Atlanta. Nothing.
Yes,
further.
Your Honor. That is our understanding of the plea. We do accept that plea and we stipulate to the factual basis, venue, and ID.
Thank you. Ms. Rowland, it's my understanding that you would like to plead guilty to criminal trespass and damage to property and giving false information to law enforcement. Is that correct?
That's correct.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, indeed.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, I do.
Has anybody forced you or coerced you to plead guilty?
No, they have not.
Okay, I will accept the plea as negotiated, Ms. Rowland. Good luck to you, ma'am.
Okay, thank you very much.
All right, you have a good day.
Thank you, Judge.
Next, we have position number 9, Ms. Foss, Brittany Foss.
This is also a negotiated plea, Mr. Finley.
That's correct, Judge.
Good morning, Ms. Foss. I'm Judge
Good morning.
Eric. Good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Ms. Foss. Ms. Tortorello?
Yes, Your Honor. This defendant's being charged with theft by shoplifting and the state's moving forward with said charge. The offer is 12 months served 9 days, credit for time served 9 days, balance probated, to stay away from all Family Dollars in Fulton County, and 40 hours of community service. Nothing further from the state.
Any objection to termination when she completes the community service?
I do have objections, Your Honor. She has several FDAs on her record, so I would object.
Okay, well, I'm going to allow it to terminate, given it's a shoplifting and the FTAs don't really have anything. Okay, Mr. Phelan, anything further?
Nothing further, Judge. Thank you.
All right. Ms. Foss, it's my understanding that you wish to plead guilty to theft by shoplifting. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Ms. Foss, I am going to waive the probation fees for you while you're on probation. And as soon as you do the 40 hours of community service, the probation will terminate, okay?
Okay, thank you so much.
So that means the quicker you do the 40 hours, the quicker you won't be on probation, all right?
Okay, thank you.
All right, good luck to you, Ms. Foss.
Thank you very much.
You're welcome.
Next, we have Ms. Hightower, position 12 and 13.
And this is a negotiated plea also?
That's correct, Judge.
Good morning, Ms. Hightower.
Good morning.
Good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me, Ms. Hightower? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
I swear the whole truth.
Okay, thank you, ma'am. You can put your hand down. Ms. Tortorella?
Yes, Your Honor. For this is a global offer. So for case number 21 CR 005585G, she's being charged with theft by taking, and we're moving forward with said charge. 12 months, served 45 days, credit for time served 45 days, balance probated, 40 hours of community service, no contact with the victim, and her name is Angela Jones, traditional spelling, and $20 of restitution to Ms. Jones. And then for 22 CR 001224G, she's being charged with criminal trespass. We're moving forward with said charge. For criminal trespass, it's 12 months, served 37 days, credit for time served 37 days, balance probated, to stay away from the Johnny store at 911 Joseph E. Boone Boulevard in Atlanta, and 40 hours of community service. And this case will run concurrent to 21 CR 005585G. Nothing further.
So you want her to do 80 hours of community service total?
Yes, Your Honor.
Okay. Mr. Finley?
Yes, Judge. We do agree to the state's recommendation. Ms. Hightower does agree to do the 80 hours total of community service and the $20 restitution. We would just ask that once she does complete each of those, if the balance of probation could either be terminated, but if you're not inclined, then not reporting, Judge.
Any objection to termination, Ms. Tortorella?
Hold on, Your Honor. I'm looking to see if she has any. She has a subsequent arrest, Your Honor. I believe it's for aggravated assault, MARTA PD. So I would like the state would request that the probation be reporting.
Ms. Hightower, it's my understanding that you wish to plead guilty to theft by taking and criminal trespass. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, I am.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced you or coerced you to plead guilty?
No, sir.
I will accept the pleas as negotiated. I'm going to waive the probation fees while you're on probation, Ms. Hightower. And when you complete the terms of the probation, it'll go to a non-reporting status, okay?
Yes, sir.
All right, good luck to you, Ms. Hightower.
Thank you. Have a blessed day.
You do the same, ma'am.
Hi, sir.
Thank you. Thank you, Ms. Hightower.
Next before you is Ms. Stinson, and I don't have my list with the position number.
Position 30,
Yes.
I believe.
30 and 31, Judge?
Okay, thank you. And this is going to be a negotiated plea?
Correct, Judge.
Thank you. Good morning, Ms. Stinson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. Mr. Train?
Your Honor, I have case 31. I believe we have other counsel with 30 for some reason. 31 is public indecency, 65 days to serve, credit for time served, 65 days. No probation. That's going to be concurrent with position 30, case 22 CR 00102F.
Okay, so 65 days, credit for time served, 65 days, balance suspended. Is that correct on both of those?
Yes, Your Honor.
Okay. So you understand it, Ms. Helen?
Yes, Your Honor. Our understanding for both cases is that it's time served, balance suspended. We do accept that plea, and we do stipulate to the factual basis, venue, and ID.
Ms. Stinson, it's my understanding that you wish to plead guilty to criminal trespass, family violence, and public indecency. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol today?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir. Yes, sir.
Has anybody forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Ms. Stinson. Good luck to you, ma'am.
Thank you.
Thank you, Judge.
Judge, before you move forward, this is Katrina. I need clarification on this plea. I just want to make sure it's time served, there's no conditions or nothing.
I'm sorry, Ms. Lewis, I couldn't hear you.
I just want to make clarification of the plea we just took. Is time served on both charges?
Yes, 65 days, credit for time served, 65 days on both charges, balance suspended.
Okay, so all the other stuff stay away and no angry management, none of that.
No.
Okay.
You wanna give me two minutes?
Okay.
Let me take them back and I have two more to bring.
Okay, the clock's running. Clock's running, Officer Milton. You start now. Take your time.
Okay.
All right, we'll be in recess until Officer Milton comes back.
Oh, I'm sorry, Miss Spikes. See, I'm rushing. Ladies, have a seat.
Ms. Helen, it's my understanding that this is a non-negotiated.
Well, Judge, it's negotiated. The only thing that ASG Mitchell and I were pre-trying in the chat was, can the 6 anger management be changed to 20 hours community service? ASG agreed, and I said that I would agree too. Should we go on record and update the conditions?
Well, I agree
yes.
to 40 hours.
40s. I apologize. 40.
Okay, all right. So, good morning, Ms. Spikes. I'm Judge Eric Morrow. This is the state court all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, ma'am. Ms. Mitchell?
Yes, the state's recommendation is 12 months to serve, 28 days confinement, credit for time served 14 days, balance probated, no further contact with Jasmine Jones, 40-hour community service, and no alcohol, drugs, and weapons. Nothing further.
Yes, Judge, that is our understanding of the plea. We would just ask that once the conditions are completed, it can be suspended or non-reporting. And we would also ask for the probation fees to be waived.
Any objection to termination, Ms. Mitchell?
No, Your Honor.
Okay. Ms. Spikes, it's my understanding that you wish to plead guilty to simple battery. Is that correct?
That's correct.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I will accept the plea as negotiated, Ms. Spikes. I'm going to waive the probation fees for you while you're on probation. And when you complete the term, the probation will terminate, okay?
Okay.
All right. Good luck to you, Ms. Spikes.
Thank you. All right, ladies, let's go. We'll be right back, Your Honor.
Okay. We'll stand in recess until Officer Milton comes back.
Please have a seat right here for me. Have a seat. Your Honor, we back.
Okay, who do we have?
Ms. McGee. Oh, he good looking.
Good morning,
Calendar, Judge.
Ms. McGee. This is the add-on calendar.
Correct, Judge.
It's going to be a negotiated plea.
Yes, Your Honor.
All right. Good morning, Ms. McGee. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir. Good morning. How are you today?
Good morning. I'm well. I hope you are as well.
Yes, sir.
Are you able to raise your right hand for me?
Yes, sir.
Okay, thank you. Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. You can put your hand down. Mr. Walker.
Yes, Your Honor. The defendant will be entering a guilty plea to 1 count simple battery. The 2nd count will merge. The state's recommendation is 12 months to serve 10 days, credit for time served of 10 days, balance probated, to remain compliant with her current mental health treatment plan, and no further contact with William O&B. This case has been on the SAP calendar 2 or 3 times. I did have the opportunity to pre-try this with PD Howard and their social worker. Initially, it was a condition of anger management, but we came to the conclusion that the mental health treatment plan would be more appropriate in this case. So that is the basis for probation and the basis for that condition instead of anger management on position 1.
Okay. And position 2?
Is going to be 12 months to serve, 10 days, credit for time served, 10 days, balance suspended. Initially, there was a stay away condition, but we are going to waive that condition as that is the Wellstar Medical Center. So that condition shall be waived, Your Honor, or omitted rather.
Okay. Ms. Helen?
Yes, Your Honor. This is a negotiated plea for both positions. That is our understanding of both negotiated pleas. I just want to put on record and notify the court that I have given Ms. McGee in her hand at the South Annex Jail an actual form which has the address and the number of the location, I believe it's River's Edge, that she will be appearing in. And I've gone over both cases with her. So Ms. McGee understands what she has to do as far as showing up at that address and calling.
Okay. And I'm sorry, Mr. Walker, is she pleading guilty to both, to 2 counts of criminal trespass?
It can merge.
Okay.
Okay, all right. So 1 count of simple battery and 1 count of criminal trespass.
Yes, Your Honor.
All right.
Understood.
Okay, very good. Ms. McGee, it's my understanding that you wish to plead guilty to simple battery and criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, I'm a full clean woman.
Okay, very good. You've been represented by counsel. Are you satisfied with her representation?
Yes, she's really sweet.
Very good. You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I will accept your pleas as negotiated, Ms. McGee. Good luck to you, ma'am.
So I'll be getting out today?
The jail will begin the process releasing you, Ms. McGee. Yes.
All right. Thank you, sweetie.
Thank you.
For everything.
You're welcome.
All right.
And Sheriff, I think that's Mr. Sheffield. Can I get an opportunity to speak to Mr. Sheffield?
Yes.
We have one more.
Oh, okay.
Ms. Kickner.
Is this your case, Ms. Helen?
Both are, Judge. If I could just get an opportunity to send the sheriff my number, just in case they can give me a call.
Okay. Or Ms. Helen, since this is the last one, you can go into a breakout room if you want.
Sure.
Okay, all right. So let's do, what position is Ms. Oh, position 34?
Yes, Your
Okay.
Honor.
Good morning, Ms. Tingle. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Is that a yes?
Yes.
Okay. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Is that a yes?
Yes.
Okay, you can put your hand down. Thank you, ma'am. Mr. Cheney?
Yes, Your Honor, going forward with the simple battery charge, 12 months to serve 330 days, balance suspended, credit time served 330 days.
Okay.
Yes, Your Honor. That is our understanding of that offer. We do agree to that offer. And we do stipulate to the factual basis, venue, and ID.
All right. Ms. Tingler, it's my understanding that you wish to plead guilty to simple battery. Is that correct? Yeah, you're gonna have to speak up for me.
Yes, sir.
Okay. Are you under the influence of any drugs or alcohol this morning?
Whatever they put in the food, yeah. No.
You understand, have you been represented by Ms. Helen? Are you satisfied with her representation? Yes?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
Sorry.
Say again? Has anyone forced you to plead guilty?
Oh, no.
All right, I'll accept your plea as negotiated.
Thank you.
Good luck to you, ma'am.
So, thank you.
Thank you, Judge.
Your Honor. Yeah, there's a housekeeping matter as it relates to that case that we need to address. And I may have brought this up before that. She has only been in custody one day on this particular charge. She served some time back in December of 2019. It was a day. She has been in custody for 334 days on a different set of charges. And if the sentence reads that she's to serve 334 on this case, the jail is gonna see that she's only served one day officially on this case, and then she could potentially be held. So I know the intent is to get her out today, but I think we need to change the sentence so that the jail won't think that she needs to serve additional time. Because even if you say credit for 334, they're gonna look at how much time she has served at the jail on the charge. Because like I said, I've had it happen and have people held for that reason. So if we can
What do you
change,
recommend, Mr. Howard?
it just needs to change to 1 day credit for time served, because that's what she served, is a day on it. Or else we're running the potential of her being held on that.
Judge, I do see that in Odyssey. It does say it's only 1 day of confinement for this particular charge, but 334 for another case.
Mr. Walker?
That's fine, Your Honor.
Okay, so 12 months is served 1 day, credit for time served 1 day, balance suspended.
Understood.
Thank you.
Okay, very good. Okay, so thank you, Mr. Howard.
Thanks.
May
So
we
let's
be
put-
excused?
Oh, yes. Will I
Thank
see you this afternoon? Officer
Yes,
Nelson?
sir. I just
Okay.
have one.
All right, so you jump on quick.
I'll wait till the end.
Okay, all right.
Okay.
I'll see you this afternoon.
Okay, bye-bye.
Let's put Ms. Helen and the sheriff into a breakout room, please. And let's see, Ms. Davis, I think you had a question that you sent to me.
Yes, I had a question.
Okay, and you were here for Mr. Marcus, is that correct?
Yes.
He's not going to be appearing before me today. His counsel has filed a waiver of arraignment. And he'll be returned to the division judge.
I'm sorry, Judge. We were booted back out. Can we get?
Okay, can we put Ms. Helen back in, please? And the sheriff? So you'll get notification of his next hearing date, ma'am.
Okay, thank you.
All right, you have a good day. So we'll stand in recess until Ms. Helen comes back.
Your Honor, I have a question.
Yes, Ms.
We
Mitchell.
didn't do position 30, right? Is position 28 the last one, Sheffield?
Position 30. Yes, that was a plea. I
Okay,
have it down as a plea. 30 and 31.
Yeah, I think ASG Cheney handled them both.
okay, gotcha. Just checking. Thank you.
Okay.
I
Any
have
other
Yeah, we
questions?
read every time served.
Ms. Tortorella?
Yes, Your Honor. Did we do position 2? It's been a while.
Okay. Let's see, that was a waiver.
Okay, all right.
All right.
Thank you.
Okay, that's fine. All right, we'll stand in recess until Ms. Helen comes back.
I apologize, Judge. The sheriff got booted out. So if
Okay.
No, they're back in the room. I'm sorry, Judge, we're having technical difficulties. Ms. Fallon should be in the room right now with the sheriff.
Okay, thank you.
Mhm.
Did you get my email, Ms. Lewis?
I'm about to check it right now.
Okay, all right, well, my message, thank you.
Judge, we're ready on position 28. It'll be a not guilty bond hearing.
Okay. You can unmute, Sheriff, please. Thank you. Good morning, Mr. Sheffield. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Sean.
Thank you. Can you raise your right hand for me, sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Sean.
Thank you. You can put your hand down. Mr. Sheffield, you've been charged in case 19 CR 008456F with interference with custody and criminal trespass. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Your Honor.
How do you plead to these charges, Mr. Sheffield? Guilty or not guilty?
Not.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Ms. Mitchell, what's the current bond?
Your Honor, there's no bond currently. This case, however, was originally given a signature bond, $5,000 per count. And then it was transferred to the DA's office, but then got kicked back down. So based on that, we're gonna recommend that the signature bond amount turn into a surety bond. So $5,000 each. Being that this was a case that was originally charged with burglary and kidnapping because the defendant kicked in the front door of Miss Yashanda, spelled YSHANDA, Finch's residence, and took the child Sommer, spelled SOMMER, Sheffield, from said residence against the child's will. The defendant does have an extensive criminal history, a violent one at that. He's been convicted of aggravated stalking, aggravated battery, family violence, burglary on first degree, and cruelty to children in the third degree, a theft by taking in violation of protective order. That's all one time in 2019, which he's rearrested on currently and serving time for. He's also been convicted of battery, family violence in 2019. A different victim, another woman, he was given a $5,000 cash bond. And he's also been convicted of simple battery in 2014, and then a disorderly conduct in 2018 that was originally filed as an aggravated assault. And we're just talking convictions here. He has what I believe is an open case from 2021 for aggravated assault, family violence, battery, family violence, and 2 counts of possession of firearm. Bond, in that case, bond was denied because the court found the defendant posed as a significant risk of fleeing. He's a significant danger to any person, the community, and to any property in said community, and is also a significant risk of committing a felony pending trial. He also has an outstanding warrant for failure to appear. I mean, it's a long list. So based on that, we are going to recommend $10,000 surety on this case. Nothing further, Your Honor.
Okay, so what is he in custody for at the present time?
The interference with custody and criminal trespass. And he was given a signature bond originally.
I mean, is he in custody for something besides this?
Yes.
Interference with custody and criminal trespass?
Yes, he's not held on this.
Right, and what is he being held on, is my question.
He's being held on the aggravated assault, family violence, battery, family. You know what, let me just double check because I know it was long. So aggravated assault, family violence, battery, family violence, the 2 counts of possession of a firearm, and then he's also rearrested for the aggravated stalking, aggravated battery, family violence, burglary, cruelty to children, theft by taking.
And those are pending charges?
So I'm not sure if he had a probation violation, which is why he's rearrested for the 2019 one, but the 2021 is a pending charge, yes.
Okay. Ms. Helen?
Yes, Your Honor. Can I have Ms. Harrison from pretrial read his history or just a clarification of it?
Yes, Ms. Harrison?
I'm showing an open case, 21 SC 179446 for aggravated assault, battery, family violence, possession of firearm during the commission of a felony, possession of firearm by convicted felon. That's in Judge Adams' court. He was just sentenced on 20 SC 174273 for aggravated stalking, aggravated battery, aggravated assault, burglary in the first, cruel to children, third degree, theft by taking.
And he was sentenced to, do you know what the sentence is?
One moment.
And Your Honor, just to note, it is the same victim, the open case and the current case.
He was sentenced on September of 2019. The disposition is not listed, but it does indicate conviction. But the actual sentence is not in Odyssey.
All right. Anything further, Ms. Helen, as far as?
No,
pretrial?
Judge, the bond wasn't holding him. We just wanted to enter the plea of not guilty for Mr. Sheffield.
Okay, all right, so, and we've done that. Anything further on for Mr. Sheffield?
No, Your Honor.
Okay, I'm sorry. All right. Good luck to you, Mr. Sheffield. And Ms. Lewis, whenever you're ready, we can go over the calendar.
Yes, sir. Please make sure you send all your paperwork to me, katrina.lewis@fultoncountyga.gov. Any orders or waivers or bond amendments. Okay, position number 1 is reset to May 12th, SAP. Position number 2, receive a waiver or arraignment, not guilty, cases reset for trial, further notice. Position number 3 was a non-negotiated plea. Position number 4, I received a transfer order from the state to transfer this case to Superior Court. Position number 5 was a plea. Position number 6 was a plea. Position number 7, the case is reset further notice. The bond was modified to $1,000 SOB through the jail. Position number 8 is a plea. Position number 9 is a plea. Position number 10 is a plea. 11 is a plea. 12 is a plea. 13 is a plea. 14, defendant was arraigned. The case is reset for jail jury further notice. Position number 5, defendant was arraigned. Case is reset for jail jury further notice. Position number 6 was a plea. Position number 17, 18, and 19, defendant was released. Case is reset further notice. Position number 20, the case is reset for jail jury. Defendant was arraigned. The bond has been modified to a $5,000 good bond. Position number 21, defendant was arraigned. The case is reset for jail jury further notice. The bond was modified to a $4,000 good bond, $3,000 on the battery, $1,000 on the cruelty to children. Position number 22 and 23 was waiver arraignment. Case is reset for jail jury further notice. Position number 24 was a plea. Position number 25, I received a transfer order to Superior Court on this case. Position number 26, defendant waiver arraignment. The case is reset for jail jury further notice. Position number 27 was a plea. Position number 28, defendant was arraigned. Case is reset back to trial for jail jury in front of Judge Richardson. Position number 29 was a plea. Position number 30 was a plea. Position 31 was a plea. Position 32 is reset further notice. Defendant was released on bond. Position number 33, I have a reset for 510 SAP. Position number 34 was a plea. Position number 35 was a plea. Position number 36, defendant was released. Case is reset further notice. The add-on counter, position 1 and 2, defendant took a plea. Any questions?
I also had that for the probation violation. That case is actually going to be heard with Judge Taylor's.
That's
and it's been
correct.
okay.
That's correct. Any other questions?
All right, you all have a good rest of the day. We'll see you next time.
Thank you.
Thank you.
All right,
Bye.
thank you,
Please
Judge.
get that paperwork over to me timely enough matter. I have to forward to the judge. I appreciate
Will
it.
do. Thank you, Ms. Lewis.
All right, Judge, I'll see you.
Thank you. I appreciate it.
No problem. Thank you.